Welcome to the Trust Factor Radio, bringing you interviews and insights to unlock the power of the subconscious mind to create authority, credibility, and trust. With your host, the Authority Architect, and best-selling author, Neil Howe.
Hello and welcome to the show. This is your host, Neil Howe, and today my special guest is attorney Paul J. Sweeney. He is a Suffolk University Law School graduate, and he helps divorce and family law clients in the Boston metro area, and he can develop unique parenting plans. He can determine how to best divide assets and negotiate a reasonable amount of support. Well, we all have problems when it comes to divorce. There's a high percentage of the population that need this service, Paul. So welcome to the show.
Well, thank you very much for having me, Neil.
I'm looking forward to getting some great information from you today. Like I said, there's a lot of people that need this help and advice. But before we get into that, give us a little bit of your background and tell me how you got started being a family law attorney.
So, Neil, here in Massachusetts, in the probate courts, they handle divorce work and family law matters as well as estates. And I had the opportunity to work in the probate court when I was a young man. And I went to law school at night at the Suffolk University Law School. And so I was getting a practical experience during the day, learning all the procedural requirements. And then in the evening, I was studying law at night. So it was really a great opportunity for me to become kind of concentrated in the family law and probate areas. And I left the courthouse almost 30 years ago and opened my own practice. And since then, I've had no problem in having clients find me to help them in their very difficult times that they're going through when they need my services. I'd also like to tell you that while I was at the courthouse, not only did I work behind the counter and become familiar with all of the procedural requirements that were required in the divorce and in the probate area, but I also went on and got an advanced degree in tax law at Boston University. So I have some degree of familiarity with the tax laws, which are important when you're doing things in the divorce area. For instance, there's recently been a change in the tax law with the new tax law that went into effect this year, and that alimony is no longer deductible by the payor, and the recipient of alimony no longer has to include it in their income. So this is a big change in the divorce area because we used to use that to kind of use the tax brackets in order to give the family a total higher support package, and it's no longer available to us because of that change in the tax law.
Yeah, it's very important to keep up with the changes, and that's many reasons why people need to go to a qualified attorney that is keeping up with those changes in order to get the best outcome. Now, as far as the divorce goes, Paul, would you say that is a large majority of your practice?
Yeah, I would say that about 70% of my practice is in the divorce area or in related issues like modifications of divorce agreements, etc. And the other 30% is in the estate area. I do some estate planning as well, which is important to do after you go through a divorce.
Definitely. Well, let's talk about the numbers. This is obviously a big problem. It doesn't seem to be going down anytime soon. But you know, what are the numbers now? I know they vary according to different outlets, but you know, how many marriages are ending in divorce these days?
Well, it's commonly said that 50% of the marriages that start today are likely to end in divorce. But one of the things that's happened in society as well is that people are not getting married and they're having families without the benefit of marriage. And so that creates a whole different area for people to be in front of the court, and we call those paternity cases. And again, those are part of the family law area, and I handle those as well. But for any people that are about to have a family, including having children, I always recommend that getting married is an important step because that gives some degree of permanency to the relationship. But what happens is that things break down over time sometimes, and there's going to be a separation. And so getting legal advice as soon as possible is probably the best thing that you can do.
Now, I know nobody really thinks about getting divorced as they're getting married, but knowing that 50% of people do, is there any advice that you would offer people even before they sign those marriage agreements?
Yes. In fact, there's an area of law called premarital agreements or antenuptial agreements. And oftentimes, people that are getting married for a second time would utilize those because they've already accumulated assets, and they want to make sure that they preserve assets for their first family before they start a second family. But more and more, I'm seeing people that have never been married before coming to my office and asking if they can get a premarital agreement. This also coincides with a lot of the younger people today in the high-tech area. They're able to find positions that provide them with a lot of times stock options, and then their company might get bought out by a larger technology company, and they have a bit of wealth before they enter the marriage. So oftentimes they want to protect that wealth by entering into a premarital agreement, and so we offer that service as well.
And is that something that is generally accepted by the partner?
Well, usually by the time that the partners are talking about marriage, they've talked about these issues, and they both understand the importance of perhaps having a prenuptial, especially if there's significant wealth on one side or the other, or they both may have wealth that they want to protect. So I've done a number of these for people that are getting married for the first time, and so far I haven't seen any back in the divorce situation, which is a good thing.
Mm-hmm. Well, yes, that is good. So let's talk about the problems when, there's obviously things that you can do to try and work things out, before it comes to divorce. But, let's talk about the actual divorce and what the major issues or problems that people run into when they're trying to get that divorce.
Well, usually when somebody's in a situation where they want to get a divorce, they're in a crisis situation. It could be that their spouse is addicted to drugs or alcohol, and is creating problems for the family. So if somebody's in that circumstance, the best thing they can do is to seek legal advice as soon as possible. But oftentimes they get to a situation where there might be domestic violence. And if that occurs, then you need to know what is available to you in terms of resources. And here in Massachusetts, domestic violence is a high priority for law enforcement. So that if somebody is in a relationship and there's domestic violence one night, they call the police on the 911. And what will happen is that the police will take the abuser, whether it's him or her, out of the house based upon the allegations that the victim of the abuse suffers. And they also have access to an emergency judge. So every night of the week, there's an emergency judge on call in Massachusetts that can issue a restraining order against the abuser and keep that abuser away from the home until there can be a hearing in the courthouse, usually on Monday if it happens over a weekend, or the next day if it happens during the week. So people need to know that that's available to them in an emergency situation. But usually the first thing that has to happen is that somebody has to stay and somebody has to go, because it just is unacceptable for them to be together anymore. So if it's not a domestic violence situation, then you really need to seek legal advice on how it is that you're going to have your partner leave the residence.
So, I mean, those are kind of extreme circumstances. Is that minority where there's, drug issues or domestic violence? Or do you see more people that are just, kind of falling apart and just want to, separate for whatever other reason?
So oftentimes when the parties have grown apart, that's usually less of a crisis, and so somebody can come in and they can get some legal advice on what to do. And so sometimes we'll explore how it is that the relationship has fallen apart, and if they've gone to couples therapy yet or not. And then I actually with most of my cases, most of my clients at some point are looking forward to maybe establishing a relationship again after they're divorced. And so I recommend to them a book to read called Getting the Love That You Want by Avril Hendricks. And what this does, it helps them understand about how they chose their particular mate and and perhaps why the communication didn't work between them and their mate. It's a very interesting book. It was published about 20 years ago, and now it's being reprinted, and it's called The Couple's Guide to Relationships. So I've been using this book in my practice for about the last 20 years. And basically, the underlying theory behind the book is that our first conscious moments as humans occurs while we're in utero, and at that moment we're experiencing perfection. However, once we're born, we no longer have perfection and rely upon our caregiver, usually our parent, to provide us with those things that we want and need. And we communicate with our parent to get those things that we want and need. When we communicate successfully, there is no pain and no disturbance in our emotions, and so we don't remember those successful ways of communicating. But when we don't get what we want, that causes us some pain, and that type of communication is then indelibly inked into our psyche. And later on, when we're looking for a mate, and there are hormones that are going through our bodies, they reactivate these feelings that we had on the way that we communicate. And unfortunately, we choose a mate that communicates in a similar manner, so that in this particular relationship, we'll be able to fix it. And unless we know that's what's going on, it's very unusual that it gets fixed in the relationship. So it's quite a book to read, and it's very enlightening. And I think a lot of my clients have expressed gratitude to me about having had the ability to read that book.
Yeah, well, you certainly don't want to make the same mistake twice, and try and just repeat the same relationship if you have the same communication problems. Now, would you say that communication is probably the biggest factor in the breakdown of marriages?
Yeah, so communication is essential to a successful relationship, and so some of the things that we talk about that get in the way, that we talk about, like we talked about earlier, domestic violence or addiction, those both get in the way of effective communication. And so having effective communication in the relationship is very important in order for it to be successful.
Mm-hmm. Well, let's talk about, obviously there's a multitude of reasons that people want to get a divorce, but let's talk about the actual split itself and what needs to be thought about. What are the major concerns for each side in a divorce?
So in a divorce, what happens in Massachusetts is that one side usually files a complaint for divorce with the probate court. And as soon as they file that complaint for divorce, they're subject to an automatic restraining order saying that they cannot move any of their assets into somebody else's name or anything like that. So usually what happens is that if there's any planning that needs to be done in terms of perhaps there are inherited assets that you want to make sure remain kind of in the family stream of inherited assets, then you might do things with those before you file the complaint for divorce if you're thinking about getting a divorce. But once the complaint is filed, you cannot change any asset scenarios without the written consent of the other side or an order from the court. So that's a very important facet of the filing of the complaint for divorce. And it's effective upon the spouse once they are served with the process on the complaint for divorce. The other thing that it triggers is an automatic discovery rule, so that within 45 days there has to be an exchange of 3 years worth of tax returns and 3 years worth of bank statements and account statements for the various accounts that people have. And what that does for the lawyers is, rather than us having to come up with our regular discovery techniques that we use in litigation, there's an automatic exchange of these documents. And so people that are not self-employed and don't have intricate marital estates, you kind of get all that information up front, and it makes it a more simplified process. There's also some people will choose to go through the mediation process and avoid the contested divorce action and try and reach an agreement with their spouse. In my recommendation, I have certain mediators that I recommend here in the Boston area, but my recommendation is that you use a lawyer that is also trained as a mediator, because the result is that you usually get a much better agreement, and it's more cognizant of some of the important factors like taxes and the level of support, etc. So that's an option for people to consider as mediation. But you always have to remember that there are 4 parties to this litigation. There are 2 lawyers and there are 2 parties themselves. And if any one of them is unreasonable in the process, then it can delay and cause the divorce to be more expensive, because the longer it goes on, the more you pay in attorney's fees. And most attorneys bill on an hourly rate, and so they bill by the time that they spend working on the case. And so if somebody becomes unreasonable and it takes much longer to resolve the case, then it becomes more expensive. I had recently had a mediation case where my client came to me and said, I want to participate in the mediation, but I'm really unsure about my spouse and whether it will be successful or not. And he did the mediation, and we did all that we could to try and get the other side to respond, and they just wouldn't respond appropriately, and so the mediation wasn't successful, and we wound up going to court. And it also was a case that I had to get into under the deadline, because we were trying to take advantage of the alimony, favorable alimony treatment, and you had to get that done before the end of the year. So 2 days before the end of the year, I was able to get the case into court, and we were able to not mediate, but we were able to come to a settlement agreement that both parties signed, and we were able to take advantage of the alimony treatment.
So that brings another couple of questions to mind. First of all, with alimony, we've got to talk about the children. What things have to be considered for the best interest of the children?
That's correct. You know the standard. When we talk about children, there are a couple of areas. First is custody. And in Massachusetts, we make a distinction between legal custody and physical custody. In legal custody, we mean that both parents usually, and there's a statute that says there's a presumption that both parents will be involved in the decision-making on the major life decisions for the child. That would be medical, educational, and religious. So these are things that you usually talk about the first time you meet the client, to determine if there are any medical issues that need to be made about the children. Are there any educational decisions that need to be made, and are there any religious differences, so that all of those things can be either brought forth to the judge or they can be addressed appropriately in the agreement. And then there's the physical custody, and again, the standard here is the best interest of the child. And what the court usually looks at, if there is no agreement amongst the parties as to how the physical custody is going to be arranged, the court will look at what has gone on in the recent past, or the status quo, as to what was happening with the children. And as long as that's in the children's best interest, they'll try and form a parenting plan that will be as close to that as possible. And when formulating parenting plans, both the court and the attorneys that work on it, they're guided by what's in the best interest of the children, and they're looking at things like how many times is there an exchange, and they're trying to make sure that there is a good relationship not only between the children and the custodial parent, but between the children and the non-custodial parent. And more we're seeing parenting plans that kind of share physical custody. And one of the types of plans that we see is a plan where the weekends are defined by Friday at 6 o'clock until Monday at school, and then they alternate the weekends, and then they divide the rest of the week by a change on Wednesday. So what happens is that the children will be with a parent for Wednesday night, Thursday, Friday, and for that parent's weekend, they'll also be with them on Saturday and Sunday nights, and then back to the other parent on Monday morning after school. And then that parent will then have them for the following weekend. They'll have them from Friday, Saturday, Sunday, Monday, Tuesday till Wednesday. So it's a plan that gives both parents and the children long periods of time together, but at the same time, not so long that the other parent is out of touch with the children. So that's one of the popular plans, and we call it a 5-5-2 plan, because there's 5 days with each parent, and then there's a 2-day period in between.
Yes, that does actually sound reasonable, rather than just the weekends and Wednesday nights. If that's the typical plan
the typical plan is the alternating weekends and one night during the week. But we've kind of we're trying to get away from that, because we now understand the role of both parents in the development of their children, and if they're both good parents, then the children benefit by having a strong relationship with both.
And what do you do when the parents end up living far apart?
So that's a little bit more difficult. So in Massachusetts, if one of the parents, say the custodial parent, wants to leave the state, then they have a whole level of a legal standard that they have to meet. And not only is it in the best interest of the child, but there has to be a real advantage to the parent that is going to try and leave the state. So that's something that when it is approved, then usually what we do is we deal with the vacation periods and the summer vacation period to have the children spend more time with the non-custodial parent so that we maintain that relationship. We also take advantage of things like Skype and FaceTime so that the children can have an ongoing relationship with both parents when the one parent needs to move for a real advantage and a real solid reason. So that's what happens when there's an out-of-state situation.
Okay. Well, let's discuss, I know you mentioned alimony at the start of the program, but let's get a little bit deeper into that. You know, how do you decide on alimony, how much, and, you know, talk to me again about the differences because of that tax law.
So most cases nowadays are dealing with child support. Because of the change in the alimony law, it's no longer an advantage to have alimony in your order. So now we're dealing with child support, and in Massachusetts we have child support guidelines based upon the income of the parties, the number of children, who's paying for health insurance, who's paying for child care, and there's a formula that gets calculated, and it comes up with the child support amount that the non-custodial parent usually pays to the custodial parent. Although when there's a 50-50 sharing of the children, we still use the child support guidelines, and sometimes the parent that makes more income will wind up paying child support to the other parent. So these guidelines are available online, but it's really important that you seek legal counsel so that you understand how they work, because there's a difference whether the children are over 18 or under 18, whether the children are in college or not, because the judge has a lot of discretion as to what to do in a situation where children are in college. In Massachusetts, you can be ordered to pay up to 50% of the prevailing UMass Amherst tuition, fees, room and board, and expenses for a child going to college. So another reason why legal advice is important to get if you're in that situation.
Definitely. It can be a very tricky situation. It's never easy to separate like that, but sometimes people have to do it. What are some of the myths or misinformation that people believe about getting a divorce?
Well, some people believe that if they have a child, that they're only responsible to pay child support until the child reaches the age of 18. But in Massachusetts, you can be responsible for paying child support even if the child is not going to school after high school, but is living with their parent and is principally dependent upon them up until the age of 21. And if they're going to school, if they're attending a college or a professional training program and they're beyond the age of 21 and under the age of 23, you can also be ordered to pay child support and or contribute towards that educational expense. So I think that Massachusetts is one of the the highest level of emancipation. That's emancipation is when the child is no longer legally, or the parents are no longer legally responsible for their support. So in Massachusetts, it can be up to age 23, whereas other states, it's 18, 19, and there is no requirement for the contribution towards educational expense.
So divorce is obviously a very emotional time and very stressful time for all parties involved. What are some of the fears or emotions that usually come out during this time?
Well, one of the fears that people have is they're afraid of the future because they no longer have the other spouse's income to support the family. So that's one of the big fears. And then there's in Massachusetts, we have a program where each party to the divorce must attend a course called the Parents Apart course, and it's 2 evenings of 2 hours, so it's a 4-hour course. And what they try to teach the parents is the importance of not interfering with the relationship that the children have with the other parent, but more importantly, to even try and build it up. This is sometimes hard to do because people might be angry that there's a divorce, and their anger is directed at their spouse, who is the parent. And so it's difficult for some parents to not say something negative about the other parent, but this course tries to impart to them the understanding that the worst thing you can do for your child is to cast the other parent in a negative light. Because the child, especially the younger children, they view their parents as the gods of their universe. And to hear one of them talk about the other one in a negative manner, it creates an unresolvable situation for the child in terms of their mental health. Because they really shouldn't be exposed to that type of behavior where one parent disparages the other, because it just creates such a conflict that the child it has problems. They'll have problems for the rest of their life if that happens. So we try to shortcut that by having the parents attend these their type of seminars, and and it's 4 hours. Now, the parents don't go to the same one; they go to different ones, but they're offered all throughout the Commonwealth, and it's a requirement that you attend before you can get a divorce. Yeah, before we get too far along, I didn't really talk about alimony, but in Massachusetts, if the parties' joint income is over $250,000, then there's a likelihood that alimony may be ordered. And we have a new set of statutes in Massachusetts that limits the duration of alimony based upon the length of the marriage. And alimony now terminates when the payor reaches the normal retirement age, unless there's some reason, some unusual reason why it should continue. So this is an Alimony Reform Act that came in 2012, and there's been case law about it in the intervening years. So anybody that's in an alimony situation, they really should get legal counsel in regard to how the alimony is going to affect their particular case. But briefly, the formula before the change in the tax law was that the payor spouse would pay 35%, between 30 and 35% of the differences in incomes between the spouses. So now that's got to be changed because of the change in the tax law, because when this statute was passed, we had the beneficial alimony treatment, which we no longer have. So what I've found in my practice is that you're getting alimony awards that come closer to a child support amount rather than an alimony amount. But again, anybody that's in a situation where they might be paying alimony, they should seek legal counsel.
So what stops people from seeking legal counsel? Is that a mistake that you see people make, is just kind of waiting too long?
Well, some people think that they just can't afford it because it is pretty expensive to hire a good attorney. And because attorneys bill by the hour, the hourly rates are kind of high. But I think that in the long run, you're well served to get some legal advice. And the first thing that you should do is just have an introductory meeting with the attorney so that you get a feel for what your issues are and what you need help with. In my firm, what we try and do is we have paralegals and law clerks, and we try and have the paralegal or the law clerk do a lot of the routine things because they can bill at a much lower hourly rate. Because what we're trying to do is we're trying to get our clients through the divorce process with as little emotional and financial pain as possible, because it really is one of the worst times of their lives.
Yeah, it's not something that anybody wants to go through, but unfortunately, so many people are going through that. Paul, if there's any questions that they really should be asking a divorce attorney to make sure that they're dealing with the right one and the most qualified one, what kind of questions should they be asking?
So the first thing that you want to be upfront with the attorney about is what their fee is going to be and how do they charge it, and will they charge you for the first meeting. Usually I don't bill for the first meeting unless the client retains me, so that way they can feel free to come and tell me their story, and then I can give them the direction that we would take in their particular case. So what I do in my initial interview with them is I explain to them, I listen to their story, and then I explain to them the process of going through a contested divorce in Massachusetts. And then after that, I try and develop what their objectives are in terms of their divorce and what the most important things are that they want to achieve. And then I try and develop a strategy that will attempt to gain that for them. And so when you are talking to an attorney, you want to know whether you're being charged for that initial consultation, and then what is the fee going to be going forward. The second thing you want to know is, where do they practice? Because in the Massachusetts, the probate court judges that hear cases, they're pretty much assigned to the same courts. So you want a lawyer that is pretty familiar with the judges where they practice, because the judges have a vast amount of discretion in certain areas, and there are some things that certain judges want to hear and some things that certain judges don't want to hear. So finding a lawyer that practices in the community where your probate court is kind of important as well.
So obviously price is an issue for most people, but what about time? How much time does it generally take to go through this process?
So again, as I mentioned before, if any one of the four parties between the lawyers and the parties are unreasonable, the time will take longer. But if people are reasonable and you can negotiate a settlement, then the time can be as soon as you reach an agreement, you can get a divorce. For instance, this morning, my firm helped a couple that had been separated for 10 years, and I brought them in before the judge this morning. We filed all the paperwork this morning, and we got them divorced this morning. But they knew what they wanted to do, and what they wanted to do was very reasonable under the circumstances. And with a couple of changes to the agreement that explained how they reached their agreement, we were able to get it approved by the judge, and so they'll be divorced. But they lived apart for 10 years, so that's not your everyday circumstance.
All right, Paul. Well, we've definitely covered a lot of questions today. If there's one thing, and I'm sure there's many, but if there's one thing that we haven't covered and you would like to talk about before we leave, what might that be?
Well, I think that what I would say is that if somebody's contemplating a divorce, that means that there's something seriously wrong with their relationship. And I don't know whether if they have a religious affiliation, perhaps they could talk to a priest or a minister. If they have a therapist, they could talk to their therapist and really get an outside view as to what's going on in the relationship, and see if there's anything else they can do to make the relationship work. Because once they come to see a lawyer, they've pretty much decided that they want to terminate the relationship, and that's kind of an important decision to make. And I hope that people make it with the best advice they can get.
Excellent. Well, Paul Sweeney, thank you very much for being my guest on the Trust Factor Radio today. If people want to reach out to you for help, what is the best way for them to do that? Well,
the best way would be to call the office, and our number is 617-742-2500, and they can speak to one of our administrative people, and they can set up an appointment to talk to either me or our paralegal.
And that's the law offices of Paul J. Sweeney, and is that at pjsweeneylaw.com?
Actually, the best email address is info@pjsweeneylaw.com.
Excellent. Well, Paul, again, thank you very much for being my guest on Trust Factor Radio. I think this has been very helpful.
Well, thank you very much, Neil, for having me on your show, and hopefully we helped out some people that are contemplating getting a divorce.
Excellent. And to our listening audience, if you like what you hear, hit that like button and share, and we'll see you next time on the show.
Thank you, Neil.
You've been listening to the Trust Factor Radio with Neil Howe. To learn about the resources mentioned in the show and to listen to past episodes, go to thetrustfactorradio.com to get a copy of the book, The Trust Factor, go to thetrustfactorbook.com. If you are ready to act now and build your authority, credibility, and trust, schedule a consultation with Neil at theauthorityarchitect.com.